Do you think it's reasonable in some circumstances to arrest a person for their speech solely because a member of that society thought that speech was offensive? Are you saying that it's reasonable to arrest a person for protected speech? Do you agree that cameras are often on tripods?
It's not always what's on a tripod, but...
Are you saying that he had the right to hit the signs?
Yes, I am.
So you've served as an expert 40 or 50 times over 30 years, and every one of those times you were an expert for the defense. Is that right?
Yes, that's correct.
Do you think that you can give unbiased opinions as an expert?
Yes, I do.
Even though you've never served as an expert for a plaintiff, ever? What field is your doctorate in?
In public affairs.
And where did you get that from?
University of Texas at Dallas.
And what did they teach you about people's constitutional rights?
Well, before I went to college, I understood people's constitutional rights is that they're protected and we hold them up and follow the Constitution and protect citizens' rights as part of our duties as peace officers too.
And how'd you get into law enforcement?
Started when I was barely 21 years old. I'd taken a test in Tyler and I had a call to go to Athens PD and started at Athens PD as a police officer in 1974.
What departments have you worked as a police officer?
Started in Athens, Texas in 74, Greenville Police Department in December of 75, and then Collin County Sheriff's Office in August of 85. And then I've been a reserve also at Wise County Sheriff's Office when I retired, and now I'm a full-time deputy sheriff, a lieutenant at Bowie County Sheriff's Office here in Texarkana.
Have you worked in a public policing agency?
You're talking about a city agency as opposed to a county?
Well, your expert report, we can go ahead and I'd like to establish Dr. Stone's expert report as Exhibit 1.
No objection.
So I'm asking about this first sentence right here. You had 15 years in senior leadership of a public policing agency. And so I was hoping you could just tell me a little bit about that, what that involved.
Oh, okay. That's when I was at the Collin County Sheriff's Office, and I served as a major over operations, an assistant chief deputy, and chief deputy.
And so the work that you've done over the years, have you investigated officers for alleged misconduct?
Yes, part of my duties as a sergeant was over the internal affairs, background investigations, and training, yes.
Did you ever see any allegations of officers violating anyone's constitutional rights?
Yes.
Could you tell me if any of those cases ever involved an arrest involving a violation of someone's right to free speech?
No, not in the officer misconduct, no.
Could you tell me what some of those cases did involve?
Use of force. Primarily, the majority of them would be use of force, unprofessional conduct, conduct unbecoming an officer.
Your report indicates that in preparing your opinions in the report, you reviewed the General Order 7.1 from the Royce City Police Department. Is that correct?
I did.
Okay, I'd like to present that General Order 7.1 as Exhibit 2. And on Article 5, Paragraph A here, it indicates that officers will at all times act to preserve and protect the rights of all persons. What does that mean to you?
Just exactly what it says, that it's part of, like I mentioned before, it's part of our duties and responsibilities to protect citizens' rights.
Do you think that these general orders are a guide for reasonable behavior of
officers? Oh, yes, without a doubt.
Do you think that the word rights as used here refers to constitutional rights?
I do.
Could you tell me a little bit about the certifications that you have?
I'm a master peace officer. I'm also a certified peace officer instructor. I'm a graduate of Bill Blackwood Law Enforcement Academy, which is an extensive academy, as well as the 189th session of the FBI National Academy in Quantico, Virginia. Also graduated from the Naval Postgraduate School in Monterey, California, and just attended a lot of other those types of training in schools.
What is a master peace officer?
The master peace officer designation is really the highest level of training, experience, and education. You're designated with a certain number of each one of those, a master peace officer.
Could you tell me about your experience as a peace officer instructor? What did that involve?
I taught at the Collin County Law Enforcement Academy, subjects in arrest, search, and seizure, use of force, a broad range over 10 years with the Collin County Law Enforcement Academy. And then for 14 years, I was an adjunct instructor at University of Texas at Dallas and taught various courses in Homeland Security, leadership, and law enforcement, different courses along that line.
You mentioned teaching about arrests. Did you teach classes about how to arrest people?
I taught classes in use of oleoresin capsicum, but not the actual physical arrest of a person, but the facts surrounding the arrest and different aspects of an arrest. Yes.
Did you ever teach about the right of a person to speak freely?
You know, I can't think specifically, but I would say that would have been part of my conversation or instruction.
I'd like to introduce Exhibit 3 as the guidance from the International Association of Chiefs of Police. It's a presentation that's titled Arrests and Investigatory Stops. So here it guides that when making an arrest, no arrest shall be made at a time or in a manner contrary to any express limitations included in a warrant or in a manner or at a time or place prohibited by relevant court decisions. If the relevant court decisions say that a person's speech is protected by the First Amendment, is it reasonable to arrest that person for that speech?
Yeah. Yes, there are times that it would be reasonable to arrest in a matter of issue of speech.
Are you saying that it's reasonable to arrest a person for protected speech?
Not for protected speech, but outside the guidelines of for disorderly conduct. Fighting words is not protected speech, for example.
Do you think that the United States Supreme Court is an authoritative source of the law in this country?
I do.
What about the Texas Supreme Court?
I do.
What about the Texas Courts of Appeals?
Yes.
Are these courts authorities on individuals' rights in this country?
Yes.
Is it reasonable for a police officer to violate the rights of an individual?
No.
So do you agree that if the courts say that an action violates an individual's constitutional rights, then that action is unreasonable?
Objection, Farm.
That action is what? I'm sorry.
I'm asking you if the courts have said that an action is in violation of an individual's constitutional rights. Is it reasonable for an officer to take that action?
Well, I would say that, all of those depend on the circumstances, but if there is a specific ruling about language, I would say it would be unreasonable for an officer to do that if there are no other variables associated with the action.
Are you saying that it's reasonable for an officer to sometimes arrest a person in violation of their constitutional rights?
No, I'm certainly not.
So it's never all right for an officer to arrest a person in violation of their constitutional rights.
I would agree with that.
Are you familiar with what the United States Supreme Court has said about the acceptable restrictions that a state can put on a person's First Amendment rights to speech?
I haven't reviewed that. I'm not familiar with the latest ruling.
Well, there's a case from 1971 called Cohen v. California that says that states can ban fighting words, and that's words that are inherently likely to provoke a violent reaction. Are you familiar with that case?
Objection form.
I'm not actually familiar with the language, but I have looked at previous Supreme Court rulings about fighting words. Yes.
This case was from 1971. Are you familiar with it?
No.
If the law says that speech is protected unless it's likely to provoke a violent reaction, is it reasonable to arrest that person for that speech?
Can you state the question one more time, please?
My apologies. If the law says that speech is protected unless it's likely to provoke a violent reaction, is it reasonable to arrest a person if their speech didn't provoke a violent reaction?
Objection form.
Yeah, I would say if it's, yes, I would agree with that.
So speech needs to provoke a violent reaction to be fighting words. Do you agree?
I don't think, no, I would disagree with that. It's to the potential, well, it doesn't have to provoke. It's the potential to provoke, not that provocation was immediate, but circumstances could rise to that level.
Okay, there's another case from 1988 or 1989, excuse me, called Texas v. Johnson. Are you familiar with that case?
No, sir, I'm not.
It says that the government may not prohibit the verbal or nonverbal expression of an idea merely because the society finds the idea offensive or disagreeable. Do you think it's reasonable to arrest a person solely because a member of society finds that speech offensive?
Objection form.
Not in every circumstance, no.
Do you think it's reasonable in some circumstances to arrest a person for their speech solely because a member of that society thought that speech was offensive?
Objection form.
Okay, ask the question one more time so I can focus on it a little better.
I'll ask you a different way. If I go outside and scream fuck, and somebody calls the police and says they were offended by that statement, should I be arrested?
Objection form.
No, especially if you stepped outside of your home and yelled that, certainly not.
So you're saying that if I'm outside my home and I shout a curse word, I should not be arrested, even if somebody found it offensive?
You're at your residence. I would say no to that.
Should people in Texas be arrested for saying speech that is merely offensive?
Objection form.
Not merely offensive, no.
What else is needed?
Speech that rises to a level that would incite or potentially cause a fight or issue related to the manner of speech and how it was directed.
So if somebody shouts curse words outside and it could incite a breach of the peace, that person should be arrested. Is that right?
Well, I would say there should be some other factors included in this, but I would certainly think that it would go beyond to a probable cause for an arrest.
If I run outside and scream, "Fuck the draft," should I be arrested?
No.
If I say, "Fuck this city, fuck the government, fuck everything," should I be arrested?
Well, the matter is potentially where you are, and the examples you have given me are outside, and so I would say that in those circumstances there would be really no probable cause for you to be arrested.
Even if there are people
No circumstances. Pardon?
What if there are people around everywhere?
Well, we've gone from you being outside of your house, and of course, that's different circumstances.
I'm asking you, if you go outside your house in a public place with a lot of people around and you shout, "Fuck this city, fuck everything, fuck the government," should I be arrested? Should you be arrested for that?
Well, I would say we have a duty to preserve the peace. So if it would have to be more than just a conversation in a can. An officer would have to make that decision based on the reaction, and sometimes we take action to protect the actor as much as we do the other citizens too. So there would be circumstances where you would take somebody in custody to avoid inciting a riot or having that person potentially be attacked.
If I go to a high school and I yell, "Fuck the city, fuck the government, fuck everything," and all the children at this high school hear it, and someone calls and complains to the police department, should I be arrested?
Well, even in our schools today, I would say that you most likely would, yes, be arrested in a public school, shouting and cursing where there are kids. More than likely, you would definitely be arrested at that school.
What if I was a student there? What if I were also a high school student there?
Well, my experience with high school students, I would say that they potentially could be, but of course they, at 17 years of age as an adult in Texas, but in most cases dealing with issues in the school, they're going to be handled by the school district, hopefully, and not by the local law enforcement.
I know, but I didn't ask you who was going to handle the...
Oh, okay. I would say, again, just in a can with this circumstance, then there's no exercise of discretion to see what the reaction is with the crowd, what the threat may be if no action is taken.
Are you saying that the reaction of the crowd is a factor in determining whether it's reasonable to arrest?
Well, I would say certainly in fighting words, that's a premise, is to avoid inciting a riot and having the disturbance that would arise out of someone who's exercising their right, but still crossing over into, inciting a breach of the peace.
But didn't you say earlier that the question is whether a speech is likely to cause a violent reaction, not whether a violent reaction actually occurred?
Yes, I did say that, and that is the point. But I was trying to answer your particular example that you were giving me at the time. Now,
Are you familiar with a case from 2021 called Mahoney Area School Districts versus BL? It's a U.S. Supreme Court decision.
No, I'm not.
Do you think that a person should be arrested if they are expressing criticism with bad words?
Objection form.
Not necessarily, no.
Even if they say fuck repeatedly?
Objection form.
Just in words alone. The words alone, I understand where you're going with your questions, but it's not a matter of just the words.
Well, what's it a matter of?
Is if it will cause a breach of the peace.
Have you ever testified as an expert before?
I have.
How many times in the last 10 years?
Probably none in the last 10 years. Before that, I've given depositions and testified in federal court some years ago.
Have you ever written an expert report related to litigation that's related to First Amendment rights?
No.
Have you ever written an expert report about your opinion about whether an arrest was legal?
Objection form.
I don't know. I'm going back a few years thinking about that. I'm not certain about that.
Have you ever written an expert report regarding whether probable cause existed?
Yes. Yes, I have. In this report, I wrote about that.
Is this the only report where you've ever written that?
No, I have some cases that are ongoing that I've written with that opinion that are still awaiting hearings and trials.
Dr. Stone, have you ever written an expert report concerning the loud, obscene, or disruptive behavior of a person?
No.
Have you ever written an expert report concerning disorderly conduct?
Objection form.
Yeah. No, not that I recall.
So this is the first time that you've ever written an opinion in a lawsuit related to disorderly conduct. Is that right?
Gosh, I'd have to, it's definitely the first time one related to speech. But I mean, I started doing this in 92, so.
But you are not aware of having ever written an expert report that includes an opinion about disorderly conduct or
about disorderly conduct. No.
You're not aware of any expert reports that you've written about that topic?
No.
Objection form.
Are you aware of any expert reports that you've written regarding resisting arrest?
I'm certain that there's probably been cases that included factors of resisting arrest related to use of force, but I can't recall exactly.
Have you written any reports, any expert reports involving a person resisting arrest?
Objection form.
I would say not in the last 10 years, I haven't.
So you're not aware of the existence of any reports that you've written involving resisting arrest. Is that right?
Objection form.
Not that I can recall, no.
So you can't remember ever having written an expert report involving resisting arrest. Is that right?
Objection form.
Yeah. Hmm. Um, thinking about it, I would have to think that I have, but I just cannot recall anything that was specifically related to matters that were related to use of force from resisting arrest. I'm sure that at some point in time in the last 30 years, I've probably written something about that.
Do you remember writing any expert reports related to disorderly conduct?
I don't. No.
When does an officer learn how to arrest someone legally?
How they learn to arrest someone legally?
When do they learn that?
When do they learn that? Well, I would think they would learn it in the academy and then have it reinforced in field training.
What are the rules about arresting a person? What's required to arrest someone?
Well, beginning with reasonable suspicion, which is required for you to stop someone. And then the next level would be probable cause, more than reasonable suspicion, to probable cause to believe that a crime has been committed. And it's based on what an officer sees, the circumstances.
So do you need probable cause to arrest someone?
Yes.
Do you need probable cause to search someone?
No. You do not.
So are you saying that it's reasonable to search someone without probable cause?
Objection.
Absolutely. Yes. Reasonable suspicion that a person has committed a crime gives you the right to search someone.
So if an officer searches someone without probable cause, that's reasonable.
Objection form.
That is not, no, that's not what I said. No.
Is it reasonable for an officer to search someone without probable cause?
Objection form.
Yes.
What is probable cause?
More than mere suspicion that would lead an officer to believe that a crime may have been committed.
Is it reasonable to arrest someone without probable cause?
No, probable cause is required to arrest someone.
Tell me about TCOLE. What is that?
Texas Commission on Law Enforcement Standards. It's the governing state agency that governs peace officer license and training and requirements.
Do they issue licenses to police officers?
They do. Yes.
And do they regulate the continuing education requirements of police officers?
Their only regulation is there are certain required courses and then 40 hours of training every 2 years.
What are those required courses?
Usually legislative updates are required, but it depends on the certification level of the officer. In my example, I have no mandated classes because I have a master peace officer license.
How does an officer lose their license?
Usually it originates with the agency and internal affairs investigation and termination of that officer for misconduct is usually how that unfolds.
Are officers required to take continuing education classes related to First Amendment rights?
I'm not anymore. I'm not certain for someone that's just a basic peace officer or intermediate peace officer or advanced peace officer, but for a master peace officer, I'm not required to take, mandated to take classes for First Amendment.
So you don't know if officers other than master peace officers are required to take First Amendment continuing education classes. Is that right?
Well, are you talking about continuing education?
Yes.
Yeah, I don't know about other officers with other certifications. They do have mandated classes, but obviously I've had a master peace officer a long time, so I'm not certain.
Is it reasonable for an officer not to receive training for First Amendment rights after they get their license?
Objection form.
Gosh, I don't, that's so broad. I'm not sure how to answer that, but I would just answer it by saying I think that TCOLE does a good job on mandated classes. So they're the agency that issues our license, so they would be the one setting that requirement.
Should officers study First Amendment rights after they become an active officer?
Objection form.
I think they should be familiar with First Amendment rights.
If an officer doesn't keep up with First Amendment rights after they become an active duty officer, is that unreasonable?
Objection form.
Well, I would just answer that by saying that we have a regulatory commission that oversees that training, and you're asking a hypothetical question about something that may exist. There may be training. I'm just saying that I'm not certain what they require for people.
I understand, but I'm asking you about the reasonableness of an officer's actions. Is it unreasonable for an officer to avoid taking First Amendment training after they're an active officer?
Objection form.
Yeah, I would just say that I would say that precedent is set, again, like I said, by the required training of the regulatory commission that governs peace officer license.
So are you saying that the minimum requirements that TCOLE places off on an officer dictate what's reasonable?
Objection form.
I don't even, we're just, yeah. So ask that question again, because I've been thinking about it, and I think I can give you a yes or no answer for that.
Is it reasonable for an officer to study the First Amendment after they become an active duty officer?
Objection form.
Is it unreasonable for an officer to study First Amendment after they become a peace officer?
Is it reasonable? I asked you if it's reasonable.
If it's reasonable, I would say that that would be reasonable for them to learn about any of our constitutional rights. That's what we do in continuing education.
Is it unreasonable not to study First Amendment rights after becoming active?
Objection form.
No, the term unreasonable may mean something different to you, but I would say, no, it's not unreasonable not to study First Amendment rights by a peace officer unless it's designated by their department, by their training, or by TCOLE.
Have you ever served as an expert for a plaintiff filing suit against a government official?
No, I haven't.
Can you give me an estimate of how many times you've served as an expert in litigation?
That would be a guess, but I'm going to say somewhere between 40 and 50 times, just a guess, over 30 years.
So you've served as an expert 40 or 50 times over 30 years, and every one of those times you were an expert for the defense. Is that right?
Yes, that's correct.
Do you think that you can give unbiased opinions as an expert,
Yes, I do.
even though you've never served as an expert for a plaintiff ever?
Yes.
Do you think officers should study how to legally arrest people after becoming active officer?
I would have the same opinion of that for that question that I do the studying the First Amendment. I think we should all strive to learn, and but if we're so specialized that I wouldn't think it would be unreasonable if they didn't.
So are you saying that it's reasonable if an officer never studies anything beyond the minimum requirements?
Ask that again. I apologize. These questions are similar. I'm just wanting to make sure I understand what you're asking.
Is it reasonable for an officer to engage in the minimum possible study after becoming an active officer?
I would say as far as the law is concerned, it's reasonable. I always strive to learn and study more. But
is it reasonable to you to study the minimum possible requirements as a police officer?
Objection form.
no, that's not what I've done. So the answer is no.
So are you saying that if an officer studies the minimum possible material after becoming active, that's unreasonable?
Well, you asked the question for myself, and then you've asked that before about an officer, if it's unreasonable. And my response is that, no, it's not unreasonable.
Well, I'm not asking about yourself. I'm asking about your opinion about the reasonable behavior of other officers.
Okay, I understood that, and my answer is no, I don't think it's unreasonable if they didn't continue to study beyond what's required.
Do you think that an officer that hasn't studied how to make a legal arrest for 15 years can make a legal arrest?
Absolutely.
Objection form.
Yes.
Do you think is it reasonable that an officer could remember an individual's First Amendment rights if they haven't studied those rights in 15 years?
I could only speculate on that question, but we're always better off if we study. Whether the matter of reasonable or unreasonable, that's so ambiguous. I don't even really understand. But if we have these things structured within departments and TCOLE to govern that, and they seem reasonable.
I ask you this because earlier you said that you can't remember if you wrote any expert reports related to resisting arrest and the use of force within the last 10 years. So it seems that you've established that 10 years is kind of a reasonable limit of memory. Is that true?
Objection.
No, that's not. I'm sorry. That's not true.
So are you saying it's unreasonable that you can't remember if you wrote an expert report about resisting arrest the last 10 years?
Well, the reason I use that time frame is I just started back working as an expert when I retired. So I think it's reasonable.
Are you saying that if a person hasn't worked with something in over 10 years, it's reasonable that they couldn't remember it?
A lot of variables there. I would say no, it wouldn't be unreasonable if they couldn't remember it.
Okay, I'd like to turn your attention back to your report. It lists here a series of materials that you reviewed in creating your opinions and conclusions in the report. I notice here that it doesn't say that you reviewed any actual laws. Is that right?
Objection form.
Well, I think I included language about I included language about disorderly conduct and resisting arrest. That's included in my report, isn't it?
Yes, you cite the language for Penal Code Section 42.01 and 38.03.
Yes.
But I'm asking you, did you review these statutes when preparing the opinions in your report?
Yes, I reviewed these statutes when, yes.
Did you review any other law in preparing your report?
Those two, and then not when preparing my report, but I did look at some different case laws.
Can you tell me what that case law was?
Well, the first one that I looked at was New Hampshire 1942 Supreme Court decision in the Chaplinsky and New Hampshire 315 U.S. 5568. I think there's another one. If you can bear with me a second, I'll see if I can.
Of course.
The other one is that I looked at was Duran versus Furr.
And you said earlier that the United States Supreme Court and the Texas courts establish what the law is. Is that right?
Objection form.
That they establish what the law is? No, I don't think that's correct. I didn't.
So are you saying that United States Supreme Court decisions are not the law?
Absolutely not. I said just the opposite.
Are United States Supreme Court's decisions the law in this country?
Yeah, they're through appeals, they set precedents in our laws in this country.
And that applies to the Texas courts as well?
Yes.
Do you think that an officer would know the law if he doesn't keep up with the court cases?
Well, most agencies provide updates, especially on legislation that's significant. So the agencies that I've worked at have, when Supreme Court has made decisions, has provided that information to the officers that were in law enforcement. And as far as I know, well, definitely in Collin County Sheriff's Office, last 36 years of my career.
Is it unreasonable for an officer to be unaware of the law as established by the courts?
Well, I would say yes. When we're out there doing our job, that there's a level of unreasonableness of not knowing or taking the time to learn. But yes.
Would an officer know the law if he doesn't study court cases?
Only in the manner that I previously mentioned to you and explained, where agencies provide Supreme Court decisions to their officers for review.
Does an officer need to study court cases to know the law?
No.
But earlier you said that the courts establish the law in this country. Isn't that right?
Yes.
So if an officer doesn't know what those courts said, how can they know the law?
By the means that I explained to you a couple of times, and that's where an agency provides those decisions to the officers for their review. in part of their training normally.
And do those materials include cases from before the officer became active?
Objection form.
Hopefully before they become active, they got it in the academy. But this is follow-up. My experience, the agency that I work for, they provided Supreme Court rulings that were significant to officers doing their job.
You're talking about new Supreme Court rulings, right?
Yes, I am.
So when an officer first becomes active, would that officer know the law if they'd not been trained in court decisions?
If they didn't have the training that I've already mentioned before, which would include Supreme Court decisions and things that affect their job, which is, I understand to be the standard. So the ideal is that they get it in the academy, and after they get out of the academy, they get updates. And again, I'm not familiar with the updates for basic, intermediate, advanced, what they get. I'm not directly involved in that anymore. And because I'm a masterpiece officer.
But if an officer did not keep up with court decisions after he became active, would he know the law?
The only way that they would know the law if they get the updates from their agency on updates from Supreme Court decisions.
But if they didn't read those updates, would they know the law?
Probably, I wouldn't assume that they would know the law, but normally they have to sign the document saying that they received it and read it. Is a normal practice in law enforcement agencies.
Okay, I'd like to turn your attention back to your reports. In your report, you list facts starting, so let's say here, for example, Sergeant Dial's contact with Winston Noles was to determine if he was displaying signs of vulgar and offensive language. During Officer Clark's contact with Mr. Noles turned away from Officer Clark and stated, "What the fuck?" to a citizen stopped at the intersection near Winston Noles' location. Video audio evidence shows Mr. Noles turning toward a truck with the window rolled down and stated, "What the fuck?" This is a recitation of the facts. Is that correct?
Yes, this is what I determined from the video as well as the officer's report.
So it appears that everything written in paragraph 1, or let me rephrase, paragraph 1 is primarily a recitation of facts. It concludes with, Sergeant Dial advised Kelley Stone that he was aware of Mr. Noles' use of vulgar language to a person stopped at the intersection prior to his arrival on the scene. So the facts end there. Then the final sentence of this paragraph is, a reasonable officer in the shoes of Sergeant Dial with similar training, education, and experience would believe that there was probable cause to arrest Mr. Noles for disorderly conduct. That's your opinion. Is that right?
Okay, yes, a reasonable officer in the shoes of Sergeant Dial with similar training, education, and experience would believe that there was probable cause to arrest Mr. Noles for disorderly conduct. Yes.
So this is an example of this same dynamic within this paragraph happens a few other times in the report. It goes directly from fact to opinion. Is there a methodology that you employed to form that opinion?
The reasonableness standard.
Did you form your opinions by applying any principles or methods to the facts of this case?
Number one, that there was reasonable suspicion to begin with. Number two, all the other facts that were presented and what I observed in video led me to the opinion that there was probable cause to arrest Mr. Noles for disorderly conduct.
Right, but are you saying that you read the facts and immediately formed the opinion?
Absolutely not. Absolutely not.
So what happened?
I watched the videos and can see for myself what's transpiring.
After you watched the videos, talked to Dial, and gathered all of the facts to inform yourself.
Mm-hmm.
Did you do anything before you formed the opinion?
Well, of course, I looked at the disorderly conduct and resisting arrest and found what applied actually in 4201. So that's what I looked at.
So you're saying that are you saying that you reviewed the case law as applied to the facts to form your opinion?
I reviewed the statute itself, and I'm not sure. I think I reviewed the case law at some point in time, but I don't think it was before I wrote that sentence.
But you said earlier that the courts determine the law in this country.
That's true. They wrote, I mean, that's where the penal code comes from, and these particular statutes, yes.
But if you didn't consider the case law when forming your opinion, was your opinion based on the law?
Well, it was based on fighting words and inciting violence or a riot. So, yes, I did consider that.
Did you consider the case law in forming your opinions in this expert report?
What I was familiar with, yes. I understand inciting a breach of the peace, something I've been trained in. We all get that training. So that's from case law.
What case law did you consider specifically?
Objection, Farm. Asked and answered.
Yeah. Again, I'm familiar with fighting words and that case law and how circumstances can get out of control in a situation like that. So,
what is disorderly conduct to you in Texas?
well, it's looking at the statute. Person commits an offense if he intentionally or knowingly, number one, uses abusive, indecent, profane, or vulgar language in a public place, and the language by its very utterance tends to incite an immediate breach of the peace.
Is that the entire law of disorderly conduct?
I've got it here somewhere. Let me take a look.
I'm asking you if you think it's possible to understand the law regarding disorderly conduct in Texas without reviewing case law.
Yeah, I would say based on your training, you don't have to review case law every day to understand the law.
Would you understand the law if a recent court decision had been issued that was not part of your training?
Well, I certainly wouldn't have that recent decision so that's usually argued in courts.
You just recited the disorderly conduct statute. We can review it here in your report. And the language by its very utterance tends to incite an immediate breach of the peace. What does that mean to you?
Well, number one, it really is dependent on location. Earlier, we were having discussions about in your front yard, but just exactly what it says that it could rise to an occasion where there's violence, a riot, or other consequences.
What Winston Noles said that day on his signs and anything he said verbally That couldn't cause actual or threatened violence, could it?
Well, I think it could. He's standing beside the road on a day where cars are passing by, stopping at a stop sign. So the answer to that is yes, it could.
Would it change your opinion if there were case law in Texas that a speaker needs to have more contact with the observer than one motorist passing by?
There's nothing prohibit a motorist from stopping. So he was 3 feet from the edge of the road.
If there was case law in Texas saying that it's not enough to say a curse word at a motorist passing by, would you agree that a subsequent arrest was unreasonable if that's what happened?
Objection form.
Yeah, I don't. Of course, here the issue is that once there's an arrest, there's a need for follow-up and done by the prosecution. So is normally what takes place in talking to witnesses and so forth. So I know in this case I still believe that a reasonable officer in Clark's shoes is the one actually that did the arrest, would have arrested Mr. Noles.
What did Mr. Noles say that threatened violence?
Objection form.
Well, it's in the report. He turned to someone and stopped at a stop sign with their window rolled down and put his arms out to the side and said, "What the F?"
So you're saying that if somebody says, "What the F," to somebody in a car with their window rolled down, that could threaten violence. Is that right?
Well, that with the signs and people calling in and complaining to the police department, stopping police officers where they were. Yes.
So you're saying that society's offense to the statements determines whether the conduct was disorderly. Is that right?
Objection form.
No.
But you just said that that a factor is whether people are complaining.
What I said is that there were numerous people stopping police officers and calling in and complaining.
And that was a factor in determining whether there was threatened violence. Is that right?
Yes, I think the potential is there for that.
And if Texas courts say that an immediate breach of the peace contemplates a face-to-face encounter, or at least something more than the impersonal, brief encounter of a passing motorist, would that change your opinion?
At this point, what I know and understand about the fighting words doctrine, that would not change my opinion.
So if I go outside and yell "fuck" at somebody that's driving by in a car with their window rolled down, and somebody calls the police to complain, should I be arrested?
No.
Why?
Objection form.
Going outside, you're providing a broad description and circumstances that I would just say no, based on the limited amount of that you shouldn't be arrested, the limited amount of information that you've given me.
If I stand on the same corner that Winston Noles stood on the day that he was arrested, with the same amount of traffic, and I yell "fuck" at a passing motorist with their window rolled down, should I be arrested?
Objection form.
I'm not sure you should be arrested if that's all that was taking place.
What else needs to
That
happen?
person's probably, well, multiple people stopping and calling in the police and complaining about signs with vulgar language while they're driving down the road.
So the difference is that people complained. Is that right?
Well, I'd say that's part of it.
If I stand on that same corner on the same day that Winston Knowles was there, and I yell, fuck this country, fuck the draft, fuck everything, should I be arrested?
Objection. Thorn.
No one complains, no one is offended, then you shouldn't be arrested.
What if one person complains?
One person complains, I think it's appropriate for the officer to contact that person and find out what's going on with the individual.
But not arrest
He has
them?
reasonable suspicion to contact that person.
Should that person be arrested?
Objection. Thorn.
I think it depends on what happens after he contacts that person.
What if nothing happens? What if nothing else happens?
Then
Thorn.
I would say if nothing else happens and they feel confident that he's not going to carry his conduct any further, then I wouldn't think that person would be arrested if that's all that happens.
So you're saying a person should be arrested because the police think that they're going to say curse words in the future?
Objection.
No, I didn't say that. What I said, if nothing else happens, refusing to identify themselves, to explain, talk to the officers, carrying it another level is a matter to consider as well too. And where it is a matter to consider.
Does a suspect have an obligation to identify themselves to officers?
Yes, when there's reasonable suspicion to stop and talk to an individual, they have to identify themselves.
Can a person be arrested if they don't identify themselves to an officer?
It would other circumstances, but if a person is uncooperative and committing an offense and fails to identify, that charge could be added, yes.
Is there a statute requiring an individual to identify themselves to police officers before an arrest?
No, not that I'm aware of.
But didn't you just say that a person can be arrested for not identifying themselves?
I don't think that's what I said. I think what I was saying is the totality of those circumstances and the individual not cooperating to even where an officer can determine what's going on with that individual. Their potential to cause more problems.
Does an individual have an obligation to identify themselves to police officers?
Yes, when they're being detained and interviewed and questioned, when there's reasonable suspicion. But if somebody's just walking down the street minding their own business, there's nothing that requires that they identify themselves unless there's reasonable suspicion to believe a crime has been committed.
So are you saying that if there's reasonable suspicion and an officer asks somebody to identify themselves, they are legally required to identify themselves?
Yes, the failure to ID.
Is that based on a state statute?
I hadn't filed that charge in a long time. I'm not certain about that.
Are there common law crimes in Texas?
No.
So logically, it must be based on a state statute, right?
Yeah, it must be based on the state statute, but I don't know the statute.
And have you reviewed that statute recently?
No, I haven't.
So just to be clear, you don't know the statute on
Failed ID
by yourself?
No, I don't.
Okay. But you do know these other statutes, right?
Objection.
Yeah, yeah.
So earlier you said that one of the factors in deciding whether to arrest somebody for the speech that they say is the number of complaints that police receive. Is that right?
It wouldn't be just that alone, but that would be part of it, especially passerbys that are upset enough to stop and contact a law enforcement officer or call the police department.
But didn't we say earlier that an essential element of breaching the peace is actual or threatened violence?
I don't remember saying that. I said that when it could, fighting words could incite a breach of the peace.
If there was Texas case law that actual or threatened violence is an essential element of the breach of the peace, should Winston Noles have been arrested that day?
Ask that question again, please. I need to focus on what you're saying.
Are you saying you haven't been focusing on what I'm saying before this?
No, I just need to refocus on what you just said.
If Texas case law says that actual or threatened violence is an essential element of a breach of the peace, was it reasonable to arrest Winston Noles?
Objection, Thorne.
If case law said that there had to be actual breach of the peace to arrest on disorderly conduct?
Actual or threatened violence is an essential element of a breach of the peace.
Actual or essential violence is a breach of the peace. In the case, in the actual case law says that, or
Yes,
you said if it does.
But you don't have to take me at my word. Just we'll speak hypothetically. If there was such a case called Woods v. State from 1948 that reads, actual or threatened violence is an essential element of a breach of the peace in Texas, was it reasonable to arrest Winston Noles?
Yes, I think it may still be appropriate to arrest. An officer has to use their discretion at an incident like this, and that's a critical part. An officer has to use their own discretion in making these decisions.
Does an officer have to know the law?
The officer needs to know the law, yes.
So is it reasonable to say that an officer should have known if there was a 1948 Texas case saying actual or threatened violence is an essential element of a breach of the peace?
Instead of unlikely, it's likely to incite the immediate violence, that it says it must have immediate violence or a breach of the peace. Because U.S. Supreme Court decision that I mentioned earlier goes back to that doctrine that allows government to limit speech when it's likely to incite immediate violence and retaliation by recipients of the words.
Was there any violence that day?
Just Mr. Noles falling to the ground on his own behalf.
Was there any other violence that day?
Not that I'm aware of.
Did any of the complainers say that they felt compelled to violence by Noles' speech?
Objection, Thorne.
No.
Did any of them say that they were angry?
Objection, Thorne.
I'm not sure about that. What was said to dispatchers or to the officers by the complainant.
To your knowledge, there was no indication that any violence was actually threatened or created by Noles' statements.
No, that's true. To my knowledge, I don't know of any.
And let me ask you again, if there were case law saying that a breach of the peace contemplates a face-to-face encounter, or at least something more than the impersonal brief encounter of a passing motorist, would it be reasonable to arrest Winston Noles that day?
Well, we're looking at hindsight, the issue of hindsight, and I still believe a reasonable officer would have detained or arrested Mr. Noles.
Well, it's not hindsight in the sense that this case is from 2003. So doesn't an officer need to know the law?
Objection, Farm.
Yes.
If a case said that a breach of the peace requires more than an impersonal brief encounter with a passing motorist, and an officer arrests a person for that speech, is that an illegal arrest?
Objection, Farm.
No, I don't think it's an illegal arrest. No.
Is it reasonable to arrest a person if that person curses at a passing motorist?
I don't think on that alone that decision was made, but but the alternative was to leave Mr. Noles there. So, and
is it
what
reasonable?
circumstance come from that?
Is it reasonable to arrest a person who curses at a passing motorist?
Not that alone. Yeah.
What would make it reasonable to arrest a person for cursing at a passing motorist?
Displays of offensive and vulgar signs to passerbys. Refusing to speak with officers when they had reasonable suspicion to interview him.
Has an individual committed a crime if they don't speak with officers?
No. Only if they're conducting an investigation and they believe a crime has been committed, they have to have the identity of the person to continue.
Has an individual committed a crime if they hold up signs with curse words on them?
Not that alone.
Are you saying that although cursing at a passing motorist, holding up signs with curse words, and refusing to talk to police individually are not enough for an arrest, collectively they are?
Objection, Farm.
I think they had probable cause for an arrest.
Why?
Just the totality of those circumstances with people complaining, the location. I mean, you could have an individual that's the location has something to do with it too, but location, the number of people complaining, the resistance to complying or identifying, cursing a passerby while the officer's standing right there trying to interview him.
Are any one of those things that you just listed a crime?
Failure to ID.
Didn't we establish earlier that failure to ID before an arrest is not illegal?
I don't know that that's true when an officer has reasonable suspicion to stop and talk to somebody.
So are you saying that the only crime that Winston Noles had committed before he was arrested was failure to ID?
No, that's not what I'm saying.
Was it legal for Officer Dial to hit those signs?
When you have an individual holding something up in front of them and you're interviewing that person, the officer has a right to search that person for weapons. So taking the signs away was an appropriate action for the protection of that officer and the other officers there involved to make sure he didn't have a weapon.
Do officers have the right to search anyone for weapons?
No, sir.
Why do they have the right to
Without reasonable suspicion that a crime has been committed, or the circumstances that an officer may stop and frisk and search someone for the protection of those officers.
So an officer can search somebody if they suspect that person of any crime. Is that right?
Well, if they have reasonable suspicion that a crime has been committed.
If
That's
if I get pulled over for running a red light and the officer sees me do it, do they have reasonable suspicion that I just ran that red light?
Yes.
Do they have the right to search
Run
me?
the red light. Yes, sir.
Do they have the right to search me?
Yes, in your immediate reach of the vehicle. They do. For the protection of the officer, and that is upheld by the Supreme Court.
If I'm holding some papers in my hand, does an officer have the right to knock them out of my hand after he pulls me over?
Objection, Thorne.
Well, how big are the papers? Are they 3x5 cards or big placards?
Are you saying that the size of the signs justified Dial hitting those signs?
The view of Noles being able to hide a weapon behind him, he could remove those signs to search him and make sure he doesn't have a weapon.
Are you saying that it was reasonable to think that Noles was hiding a weapon in between the signs in his hands?
No. Could have it on his person, not in his hands, on his person.
So why was it reasonable to hit the signs?
So he could see if there was a weapon or any view of a weapon.
So are you saying that he had the right to hit the signs?
Yes, I am.
He had the right to hit the signs because he was looking for a weapon that was not in his hands.
Yes.
And that was reasonable to do.
Yes.
To your knowledge, when officers are conducting searches, do they always slap things out of your hands?
In that situation, it was reasonable.
Why couldn't they search him for weapons without knocking the signs out of his hands?
Objection, Thorne.
It was uncooperative. He wouldn't even show him the signs. So
Would it have been reasonable to ask him to hand over the signs?
they did ask him to show him what's on the signs.
Would it be reasonable to visually inspect his person for weapons?
That's exactly what he did.
So is your definition of a visual inspection slapping signs?
Objection, Thorne.
No, it's not.
So he did more than a visual inspection. Is that right?
He removed an object that obstructed his view of the majority of the person's body.
Could he have changed his vantage point to get a different view?
Objection, Thorne.
I don't know, big signs. Hard to say.
What is the factual basis for your assertion that Dial hit those signs to protect his officers and search for weapons?
Well, it asked to see the signs, and the individual, they had reasonable suspicion that a crime had been committed. Well, therefore, they had the justification for search, and the signs were blocking the view. They're big enough that he could have a weapon in his waistband or anywhere else. So that's my basis for that opinion.
But you just said that he hit those signs to search for weapons, correct?
Well, what I was saying that was the purpose of getting the signs out of his hand would be my position on it.
How do you know that was the purpose?
Well, when I interviewed him, he told me that he had knocked the signs away, or he was concerned about the person having a weapon.
So when you gathered information about this case and about the actions of Dial, you derived most of your facts from the phone call. Is that right?
No, not at all. Most of the facts that I got were from the audio and video that I watched for each one of them for an extended period of time.
You're saying that Dial told you that he hit those signs to search for weapons. Is that right?
I don't know whether it was inferred or we had a discussion about it. Anyhow, I believe that's the reason that he hit the signs.
Did he tell you that's the reason he hit the signs?
Oh, I did read it in his deposition that we just had gotten recently. He had mentioned that, so that's where I got that.
So he didn't tell you that when you talked to him?
No, I don't. I think that's where I got it, was reading it in the deposition.
Did you ask him when you talked to him why he hit the signs?
No, I didn't.
Did you think that was relevant to your opinion in your report?
No, I didn't.
You're saying that you didn't think that it was important to your opinion in this report whether Dial had a legal foundation for hitting those signs?
Not that I could see. I mean, we don't need a legal reason to knock a sign from somebody's hand. Well, I don't understand that question.
Do you need a legal reason to hit a sign?
No, other than to search. I mean, that's what he said was his intent.
And you're getting that from his deposition, is that right?
I did.
Not from the call with him?
I don't think I asked him about it in the call.
So would you agree that if he didn't say that in his deposition, then that's not the reason you hit the signs?
My understanding is that's why he hit the sign. So, but an officer can take whatever action they think is necessary to search or protect themselves or the others that are at that scene.
Now, what you're saying is interesting because these depositions occurred after you wrote your report.
That's true. There's nothing in my report about it, just your questions.